and the coordinator of today's lecture, Dr. Alka Patil, for bringing this forum to me and giving me this chance to address all students of the first semester and more. So the talk today is supposed to be about law and social transformation. So I've been dealing with this subject, this paper, in two of the groups. And today I'll have a chance to, I think, talk and interact to people from the other groups also. So let's begin our talk. So in law and social transformation, the first thing that we need to talk about, the first thing that we need to refer to is how law is essential to social change, how law plays a role in bringing social change. Now, social change can happen on its own. Society is something that is always in a state of flux. It's always changing. It's always altering. It has a bearing on the law as well. But sometimes we can use the law as a trigger to bring social change as well. So the two are interrelated. The relationship between the two is symbiotic. Just as we can use law to take social change in a certain direction, on the other hand, what happens is sometimes it is the social change that gives a direction to the legal changes. So this is the sort of relationship that we see between law and society. Now, in social change, how do we connect it with the law? First, let's see how law is used to bring social change of a certain kind. In countries where, in our part of the world in particular, where we have had influences of various legal systems from throughout the world. In our country, we have had influences of legal systems which have grown indigenously in our own country from the ancient times. We have had influences of legal systems that were brought in by people who came to rule us at certain points in time. Then there was a colonial period in which laws from the European continent, their values, their legal values came to be reflected in our law. So in our country, we have seen a lot of legal ideas, a lot of ideas as to how law can be used to give a certain shape, to give a certain form to a society because of the play, because of the influence of these legal systems. So in India, law has been used as an instrument of bringing social reform. This is not just the case with our country. In our other countries also, such measures have been used. But what we see is that these measures are used more commonly in countries which have been colonized in the past. So there is a social ideal that emerges from the international scenario. There's a social ideal that emerges from the colonial influence, and there might be a social ideal that might emerge from our own experiences also. So in order to achieve that social, the sort of society that we want, that's the social ideal that we want to achieve, we can use law as an instrument. So what happens here is that we make laws which are aimed at bringing social change. We bring in laws which trigger social change. So there are many such laws that we see in our country. If we look at the laws relating to dowry, if we look at the laws relating to abolition of child marriage, if we talk about laws that relate to various other social evils, immoral traffic. So all these laws are reformatory laws. So what is the purpose of law here? Labor laws as well. So what is the purpose of law here? The purpose of law is to give direction to social change so that the social change that happens conforms to the ideal society or the social ideals that we aim to achieve. However, sometimes it works the other way around as well. Sometimes the society changes first, and later law takes into recognition, law incorporates within itself the changes that the society has already seen. If we look at laws like the Domestic Violence Act of 2005, in that we see, I've been giving this example in my class quite often, that it talks of relationship of marriage, and in addition to that, it talks about relationship in the nature of marriage. Now, what is this relationship in the nature of marriage? Now, this is something where the relationship in nature is similar to a married relationship, but it is not actually a married relationship. So there might be such instances where the fact of a marriage between the parties is difficult to prove, or let's suppose a marriage has not even taken place. The couple has started living together and they perform their duties as if they were husband and wife. So in such relationships also, it is possible that domestic violence takes place. Now, until such relationships were insignificant in number, the law did not take these into cognizance. But over a period of time, what we are seeing is such relationships have been rising in number. So they are becoming relatively, in relative terms, more common than they were earlier. So what has the law done now? So the law has taken cognizance of those. And now there is a law that deals with domestic violence in such relationships as well. So this is how it is not just law that changes society. Sometimes the changed society also requires a change in the law in order to grow further, in order to develop further. So if we want to develop our law further, basically we have to incorporate and include the changes that the society has seen and reflect that in the legal system. Moving beyond that, what is the juristic view? What is the jurisprudential side of it? Have jurists talked about these issues? The answer to that is, well, to an extent, yes. If we look at jurists from continental Europe, particularly the jurists we have been studying as a part of sociological school of law, here I would specifically refer to Eugen Ehrlich. Now, he distinguishes between what is called formal law and what is called living law. What is formal law? Formal law is the law that is written in the statute books, the law that is supposed to apply in a certain society, law that the formal mechanism of the functioning of the state says should apply. And the living law, on the other hand, is the law that actually applies on ground. Those are the real life situations. Those are reflected. The real life situations are reflected in the living law. So here, the living law sometimes is very different from the formal law. So in legal systems which are more efficient, the gap between the formal law and the living law is less. In legal systems that are relatively less efficient, in legal systems where what is written in the statute book, what is written as the law, and what applies on ground, if these are very different, then we say that this legal system is inefficient. So there the gap between the formal law and the living law is greater. It's just much higher. The example that I often quote in the class, which is I think the simplest for the students to understand, is that the formal law is that students have to attend 75% of the lectures as per the Bar Council of India rules in order to appear in their examinations at the LLB level. So that is the formal law. The living law, well, I need not say much about it. It is very different from what the formal law states in many of the colleges. I'm not saying all of them, but in a significant number of colleges, there's a big gap between the formal law and the living law. So this shows that as per Ehrlich, it is the society that changes first. The society, since it is always in a state of flux, since it is always in a state of change, it moves ahead. When it moves ahead, when it changes, when it alters itself, it has its own needs and requirements. When it has to fulfill those needs and requirements, it develops certain usages, certain practices, which become the living law, which become the norm in society. Right? There are do's and don'ts which emerge out of it. So uh, the living law emerges first, and it comes with social change that happens on its own. Later, what happens is that the state takes cognizance of that social change. State takes cognizance of the practices and usages that have developed in society, and they incorporate that into the formal laws. So formal law tends to follow the living law. This is how Ehrlich sees it. Now, Ehrlich was uh, writing in continental Europe. So in those systems, maybe at the time when he was writing, maybe there was a grain of truth in what he said. But in case of countries like India and other countries which have been colonized in the past, where you know the social change that happens is expected to conform to an ideal that might have emerged elsewhere in the world. So in those systems, sometimes we frame laws beforehand, and then we ask or we expect the society to follow those laws and accept the change that results out of it. Right? So I'm not saying that such practice is there only in the developing world. It doesn't happen in the developed world. In the developed world also, there are reformatory laws. But those are less common in that part of the world and relatively more common in our part of the world. It's not that it doesn't exist in those systems and only exists in our systems. I'm not trying to keep these systems in watertight compartments. Basically, the change in law because of change in society, as well as change in society because of change in the law. Both things happen in all legal systems. It's just that the percentage of one thing might be more in developing countries and the percentage of the other might be more in the developed world. So that is the situation that is. In addition to this, when we talk of law and social change, we cannot ignore another important social legal thinker, a prominent member of the sociological school of law, Dean Roscoe Pound. Roscoe Pound talks of what the purpose of law is. According to him, the purpose of law is to reduce the friction between competing interests. Now, these interests might be interests of the individual, interests of the state, and the interests of the society at large. So, now the interests, when Roscoe Pound talks about it, those interests are not just needs. Those interests also includes wants and desires. So needs might be assessed, needs of one person might be accessible by another person, but the wants and desires involve an element of will of a person. So the idea of interest that Roscoe Pound talks of is a very broad idea. It has this element of need also, and it has this element of wants and desires as well. So the will of the interest holder also is taken into consideration. So it's a broader idea than some of the other writers like Eyring. So now in Roscoe Pound's case, what does he say? What is the purpose of law? The purpose of law is to reduce friction between these competing interests. These interests might be, as I said, individual. These interests might be interests of the state. These interests might be social interests. What is this friction? Friction means wherever there is a possibility of conflict. So sometimes my individual interest might clash with the interest of my country. Sometimes my individual interest might clash with the interest of society at large. Let's suppose I dislike somebody, or I have an enmity with someone. My interest might be that this person suffers some kind of injury, some kind of damage, some kind of loss. But it might not necessarily be in the interest of the society, because in the social interest, safety of everyone in society, progress of everyone in society, that might be the social interest. So sometimes our individual interests and the social interests, they come in conflict with each other. Sometimes our individual interests and the interests of the state come in conflict with each other. And sometimes the interests of the society and the interests of the state, they come in conflict with each other. So what is the role of law here? According to Roscoe Pound, the role of law is to reduce this clash, reduce this conflict between one kind of interests and the other kind of interests. Basically, the role of law is to moderate those different interests and moderate and accept those interests, incorporate them, uh, facilitate their realization up to a limited extent through the legal system, and ensure that wherever the point of conflict comes in, at that point, by regulation, it should be the realization of those interests should be stopped. So, to what extent should interests be realizable, and to what extent they should not be realizable? That can be decided by law. If law can decide that, it would reduce conflict between different kinds of interests. So that is how Roscoe Pound tried to explain this. His theory is called social engineering. When we hear the word engineering, it appears that you're trying to create something, to form something. Let's suppose engineer. If we are trying to engineer a bridge, what would happen? First, we draw up a design, then we do the testing, then we assess whether this design would be feasible for such a situation. So then modifications in the design might be needed as per gaining of knowledge through the surveys, etc. Or sometimes we do the surveys first and then we start with the process of designing as per the data that we receive through the survey. So depending upon the situation, one of these measures, one of these mechanisms might be adopted. And then that plan that has been drawn up is supposed to be executed. So you create a new bridge after doing the survey, drawing up the design, and then putting that into implementation. So here, when Roscoe Pound talks about social engineering, he's not trying to create any new society. Basically, why he talks or why he uses the term engineering is because he wants a scientific approach to be taken while dealing with different interests. That the action or the law that is framed based on the interests and the extent to which those interests should be furthered by the law, this should be based on data. This should be based on scientific analysis. So it is to reflect that scientific approach that he uses the word engineering. He doesn't use the word engineering in terms of creation of a new society. That is not the way he sees it. That is how he tried to explain his opinion. But what are we talking through all this with? That law changes and it brings social change, and sometimes the society changes and we have to change the law accordingly. So both ways this operates. So sometimes we do it for reasons of incorporating the social change into the legal system, as the transition from living law to formal law, as mentioned by Ehrlich. And sometimes we draw up laws, as Roscoe Pound talks to us, as Roscoe Pound mentions, to reduce the conflict, to reduce the friction between competing interests. So, if either these ideas are not in conflict with each other, they're not really different. It's just that they have stated something similar into ideas are not in conflict; they are compatible with each other. So this is where this is how we can understand this idea of law and social change. Social change changes the law, and changing the laws leads to further social change. The relationship between the two is similar. So sometimes the pace of this change is fast, sometimes the pace of this change is slower. Sometimes the change that happens is as per what we contemplate beforehand. Sometimes that change might be different from it, because when we frame laws first and we expect the society to change according to those laws, the society might not always behave in furtherance of those laws. Social change has a mind of its own sometimes. So laws are made today in contemplation of what the situation in the future is going to be. So sometimes the future situations are different. So we have to adapt the law accordingly. So that is why we always have to keep in mind, we can use law to bring social change, and at the same time, we should have reasons, and we should have mechanisms to bring legal changes owing to changes in society. So that is the sort of relationship that we have between law and social change. Just in case there are any queries, you're welcome to type them in the chat, and as soon as those are conveyed to me, I'll take those up. Moving further until those questions come. So that relates to law being a product of our traditions and culture. Now, should the law result from our tradition and culture? The idea of law being in accordance with tradition and culture is an idea that has been weighed, that has been assessed by various writers. This is an idea that is a good idea up to a certain point, within certain limitations. And beyond that, we tend to see certain difficulties, certain problems, certain, undesirability of such thing happening sometimes. Now, traditions and culture. Culture is a very wide word. It's an omnibus word. It can include a lot of things. It can include elements of language. It can include elements of literature. It can include elements of race. It can include elements of customs. It can include, the way people eat, the how much they travel, where all do they go, their religious beliefs, their faith. All those elements can be included within the broad meaning of culture. Culture is a very broad thing. And related to that is the idea of tradition. Tradition is what is practiced in society, what is followed in society. Now, traditions are something that are actually followed. It's not some ideal that the society lays down. It's more in the nature of what society actually tends to follow. So that is the idea of tradition. Traditions, because in order to emerge as a tradition, something has to be followed in society for a significant period of time. That is what is only then that we start calling it a tradition. It is something that is followed consistently for quite some time. Does it relate to our customary practices? The answer is yes, undoubtedly. What are customs basically? These are also do's and don'ts in society. Some customs have, a legal implication. Some might not. But if you look at the idea of customs, customs are basically social practices that have been followed for a long period of time. Why are they followed for a long period of time? Because maybe the society found them useful. That is one reason. Two, it might further the interests of some powerful interests in society. That can also be the reason why customs continue to be followed. But then, following customs in the times when they emerged, that might be a good idea sometimes. It can also happen that over a period of time, with social change, the relevance of following that custom might reduce, or it might die out also. Since customs tend to be unwritten, so many of them are forgotten, many of them are given up, new customs emerge over a period of time. That is how the cycle of development of customary law goes on. But over a period of time, what are we seeing? That our law has become more and more formal. If we look at the Roman legal system, they started with statutory law for a very, very long period ago. It's a very long time ago. The 12 tables of Rome are understood to be one of the oldest forms of legislation, written legislation. That might be the case for the Western world. In the Eastern world, well, there must have been laws. They might have been in writing also. Well, owing to our tumultuous history, we are less likely to come across examples of those. But nonetheless, we can safely assert that in most of the legal systems around the world, the idea of formal laws, the idea of written laws, has been there in many civilizations. But the point that we are trying to discuss here is that should the law in the present day times be a product of customs and tradition. Now, in this case, sometimes some customs, some traditions, some cultural elements, they are desirable to continue, or it is desirable to continue with. There are certain traditions in society which continue to be beneficial, which can carry significant social benefit, and they should be carried on with. And then there might be some other traditions which perhaps become a bit outdated or sometimes undesirable with social change, and they need to be given up. So in common law world, in countries where the legal system uh, sees its roots, or has connections with the English legal system, in those places we talk of essentials of a valid custom. When should we accept the custom as law, and when should we give it up? So there are some essentials of a valid custom. It includes things like antiquity. One, the custom should be old, significantly old. The English position on it is that the custom should have been in prevalence at the time of the first year of the reign of King Richard I. So that was, well, if there is evidence to the contrary, then it is this custom is not seen to be there since that time, and that is their understanding of what time immemorial means. In countries like India, we are more flexible about these things. So our customs need not always be as old as that in order to be valid. Anyway, so, but the requirement of antiquity of a custom, the requirement that the custom should have been followed for a significant length of time, that is there. So antiquity of a custom is the first essential. Then we also see things like consistently followed, continually followed. So the custom should not have, there should not be any time frame when the following of the custom is given up. If the continuity of the following of the custom is lost, the validity of the custom is lost in common law systems. So the custom should have been continually followed. Then this custom should be consistent with the statutory law. So whenever there is a conflict between the written law, the statutory law, and customs, it is the statutory law that usually prevails. There might be exceptions to that once in a while, but in the basic common law principle regarding essentials of a valid custom is this. Then this custom should be such that it is not in conflict or should not have been overruled by a decision of the court, because in common law countries, we have a system where the courts can lay down the law through their judgments. So the custom should not be in conflict with that. Court can overrule the validity of a custom. And other than that, this custom should be consistent with other customs. Customs should not be in conflict with each other. If there are two customs and they are contradictory, then both are seen to be not valid. In addition to this, the custom should be reasonable. This reasonableness has to be assessed at the time when the custom emerged, when the custom started. So the reasonableness of a custom can be assessed in terms of when it started. So it need not be reasonable in today's times in order to be valid, but it should have been reasonable at the time when it began. And then how to take into consideration the present day times? The custom should be consistent with public policy. Public policy is based on contemporary concerns. What is public policy? Generally, the court decides that. So when the court assesses that a custom is not in accordance with public policy, then it is no longer the law. So that happens to customs. But the idea of culture and traditions is not limited to customs only. Culture can be contemporary culture also. Culture can be current culture also. And it can be a culture that we draw from the past as well. Culture is a continuum. It can be, it is there. It has its elements that come from the past also. And it has elements that are contemporary as well. So when we talk of this, I'm sorry, when we talk of culture, sorry, uh, we talk of contemporary culture as well as culture which is traditional culture, which is older. Uh, Various jurists, particularly from the historical school, again have talked about a related issue. Here, I would like to mention the name of Friedrich Karl von Sabine, as he talked about desirability, not necessity, but desirability of law being in consonance with Volksgeist. Volksgeist basically is the spirit of the people. The Volksgeist is a German term that directly translates as the spirit of the people. So, what he said, that it is desirable that the law should be in consonance with the spirit of the people. Why is it desirable? Because if something is in accordance with what the people think that their spirit is, people accept, then effectiveness of that law, efficiency of that law, the acceptance of that law in society is much greater. So it leads to more efficient law. It leads to more effective law if the law is in accordance with the Folksist or the spirit of the people. So Savigny basically advocated that laws should be framed in furtherance of the Folksist, in furtherance of the spirit of the people. Now, this spirit of the people, how is this known? How can it be assessed? Now, this can be assessed from, again, the culture. This can be assessed from the traditions that are followed in society. This can be assessed from how society behaves and acts. So we can delve into the past and assess what the spirit of the people currently is. In fact, Savigny advocated acceptance of Roman law as a part of the folksist of the region that we call Germany. In those days, Germany was not one single country, it was divided into various principalities like Weimar or Saxony, or the different parts of Germany were independent principalities. Prussia was, incidentally, Savigny was from Prussia, the northeastern part of Germany. Now, uh, as per Savigny, it is beneficial, it is desirable if the law is in furtherance of the spirit of the people. And to reinforce this idea, what he said was that Roman law, as it was accepted in Germany in the earlier times, that should be treated as a part of the German Volksgeist. Now, here we are talking about the spirit of the German people. Romans are an altogether different culture. So, how can Roman law become the spirit of the German people? So, Savigny believed that since Roman law had been applied in the region that constitutes Germany for such a long period of time, it has become ingrained in society, it has become accepted in society, and hence it has become a part of the German Volksgeist. It has become a part of the spirit of the German people. So it's not that the spirit of the people is a settled idea, or it is a fixed idea, or it has to be based on the traditions and customs of that community only. Influences from elsewhere can also be seen to be a part of the spirit of the people. So this was accepted by Savigny. Anyway, that is an idea with a limited premise, because in some laws, like laws relating to marriage, laws relating to succession, the spirit of the people might be more relevant. People would be more, you know, uh, accepting of the laws which are in accordance with what the society accepts and follows. People would be, following the law more efficiently if the law is similar to what the people think, similar to what the people believe. However, in some kind of laws, it does not matter much. When we talk of laws relating to contract, laws relating to uh, carrying on of business, e-commerce, laws relating to information technology to a certain extent, then any other technical laws which are there. In those laws, the spirit of the people does not matter quite as much as it would matter when it comes to personal laws. So what Savini was saying was perhaps right, but it was right within a limited premise. So when it comes to society and social change, when it comes to social transformation, well, the spirit of the people, if that is incorporated into the law, it does lead to a more efficient law. It does lead to a law that is more likely to be accepted by the people, more likely to be followed by the people. So, this idea of following culture and tradition and the laws being a product of the same, this is also a healthy idea. But again, this is a healthy idea within certain limitations, as there might be certain elements of tradition, there might be certain elements of culture which we would like to give up. Some things might be undesirable in today's times, in changed circumstances. Then, if the law is based purely on traditions and culture, then it would be very difficult to reform those laws. So reformatory laws tend to go against traditions and culture generally. So those reformatory laws, as we have already talked, those are essential as well. Those also have to play an important role in society's development. So in that sense, we cannot limit our laws to tradition and culture. We should consider tradition and culture. We should think of tradition and culture while framing laws. It's a good idea. It's an idea that makes laws more efficient. But wherever it is not desirable in the current times to continue with such traditions or such cultural practices, then we can give up those practices and bring in laws which go in conflict with those also. So this is more a question of being considered rather than being followed. So traditions and cultures ought to be considered, but need not necessarily be followed. They should be followed only if it is desirable to follow them in the current circumstances. Not it should not be necessary to go by traditions and cultures, because culture also, as I said, a large, a significant part of culture is contemporary culture, and that can change with changing times. Then another aspect that is there in the syllabus is the effect of colonization on our law, the common law system. So first, let me mention a few things regarding common law. What is common law? And then we will come to the effect of colonization on our laws. So the idea of common law. Now, this essentially relates to the emergence of law, development of law as we see today in the UK, primarily, in fact, to begin with in England, and then the same idea extended elsewhere also in the UK. And then these ideas were carried further into all those countries which were under the British influence, which were under the British control, uh, or which had very close relationship with the British legal system. So primarily, you see common law being followed not just in the UK, but in all other places where the UK has had colonies in the past. So when we talk of countries like the US, the United States, when it was first formed, it consisted of 13 former colonies of the British. It has now today, it has grown to 50 states, but it started out as a collection of 13 colonies. Then Canada, which, even in fact, Canada still has very close association with the idea of common law, and continues to maintain close political relationship with the UK. In fact, the head of state there in Canada, Canada hasn't, this head of state in Canada, I think it continues to be the English monarch. So Same is the case with countries like Australia, South Africa, Nigeria, Kenya, India, Pakistan, Bangladesh, parts of Myanmar, Singapore, some areas in Malaysia. So in all these areas, we saw the control of the British. And when the British ruled, they carried some elements of their legal system with them and implemented those in the colonies as well. So even in today's times, the principalities or the areas which are under the British control, whether we are talking about Turks and Caicos Islands, we are talking about Falkland Islands. So in all those places, the idea of common law has been carried to, and the local legal systems there, they work in accordance with it. And this idea is not limited to countries who are members of the Commonwealth, British Commonwealth. The US is not a member of the British Commonwealth, but in spite of that, the federal legal system in the US follows common law, and among the states also, I think barring one or two states, Louisiana, I think, which follows civil law system, all other states in the US follow common law system. Now, what is this common law? How is it different from civil law? I've been referring to these two terms. The thing is that maybe we don't have real time to go into the background in detail, but to a certain extent, I would refer to the emergence of common law here. Europe went through a phase in history that is known as the Middle Ages. During that phase, the influence of religion and the influence of the clergy over the people was very strong. Before that, there was Roman Empire that extended to various parts of continental Europe. So Roman Empire was earlier, then came later. Middle Ages came later than that. But when the Middle Ages started coming to an end due to various political changes, so due to paucity of time here, I won't, I cannot in fact go into the details of what political changes were happening and where. But Middle Ages came to an end. We saw this era of Reformation and Renaissance. And it is during this period that the influence of religion waned, and there was a rise in the powers of the rulers, the kings, the princes. The role of adjudication, the role of dispute resolution also passed out of the hands of the clergy, out of the hands of the religious scholars, and it started flowing into the hands of the rulers, the kings, the lords, the feudal lords also. In continental Europe, since before the Middle Ages, they had this tradition of following Roman law. So when adjudicatory mechanisms were set up, when dispute resolution systems were set up by the kings, they had a law which they could follow. Roman law, as we know, has a long tradition of putting things into writing. It has a long tradition of codification. Those codes were still available. They were still accessible. And continental Europe could take inspiration, and it could be influenced by the Roman legal system that applied, that had its effect over continental Europe. But in the UK, England and the neighboring areas, the territories under the control of the English at that time, whether it was Wales or Scotland or Ireland, in those territories, there was not much of a history of application of Roman law. Romans captured only some parts for a short period of time. Some territories like the city of Bath, maybe Mumble, some other small places. But there was no sustained application of Roman law in that territory. So it has not become a part of what people would accept as law. So whereas in continental Europe, after the Reformation and Renaissance, the legal system used the principles that were laid down in Roman law. That is why, and since they use the principles from the ius civil, that is how they used to refer to the civil side of Roman, the ius civil. So the ius civil, or the codified part of Roman law, uh, that formed the basis of the legal systems that emerged. And we know that Roman law had its roots in natural law. So those elements formed a part of the legal systems in continental Europe. So in their legal systems, they lay down a statute, lay down a codified law, and for every decision to be made, every adjudication that is to be done, every dispute that has to be resolved, you refer to the written law, you refer to the code for an answer. Whereas in the United Kingdom, since there wasn't much of a tradition of Roman law, when the king set up their courts, they had to decide cases on the basis of what the common people there understood to be right or wrong, what the common people there assessed to be right or wrong. It is based on the perception of the people as to what is right and what is wrong. There was no codified law on which they could base their decisions. Their decisions were based on the social norms, the social moral norms. Over a period of time, the decisions of the courts started getting recorded in the form of reports. People started writing reports of what the courts decided. And in later cases, they used to cite those reports that, my lord, in the past, judicial mind has been applied to this issue. This was the decision that was taken. This is how what the law is on this issue. Please apply similar principles to our case also, since our case has primarily the same situation. So they started citing old decisions of the courts in the newer cases. Over a period of time, since it is not just reports by hand that emerged, they became more accessible with the development of printing. As the printing press was invented, more copies of these reports could be printed, and these reports became more and more accessible. Education was also increasing during the period of Renaissance. Common people started getting educated. Large number of people could read and write. The ability to read and write was no longer limited to those associated with religion. Ordinary people could also read and write. There were opportunities for the same that were emerging. So what happened was that these old decisions of the courts became more accessible in society, and they came to be cited in later cases also. Then it became a tradition to largely abide by the same principles which have been applied in deciding cases in the past. So if one principle, legal principle, has been the basis of a decision in a case in the past, and a similar case comes up later, the same old case would be cited. And since it became traditional to follow those principles laid down in the past, this idea of old cases and the principles laid down therein being binding in the courts emerged. So this is what we today call the doctrine of precedent, or the doctrine of stare decisis, which means that the settled points of law should not be deviated from. So in the common law system, what happens is that in certain older cases, the courts lay down principles and they serve as the law for the future. So this law is not codified. It is not put in organized form. It is not put in a structured form. It is to be deduced from the decisions in earlier cases, right? And it is binding law in future cases. So this idea of growth of law through decisions of the courts, this is known as common law constitutionalism, and the body of law as a whole, which is which is hidden in those decisions, which is implicit in those decisions of the courts. That body of law collectively is referred to as the common law. So what is common law? It is that set of principles which have been the basis of decided cases for the courts in the past. All those principles taken together, now we refer to them as common law. So in common law, the advantage is that it is not just the legislature which can frame laws. Codified laws are possible, of course, but the courts also can add to the meaning of the law. Every time the court interprets a codified law, it adds meaning to it, and this is how the law expands further. Sometimes our statutes are silent on certain legal issues. There also the courts give decisions which serve as the law until our legislators choose to legislate on those issues. So that is how common law constitutionalism functions. Even today in India, if you look at the constitution, we have Article 141 of the Constitution, which says the law declared by the Supreme Court shall be binding on all courts in India. What does that mean? That whatever the Supreme Court declares as the law, there is no binding thing on Supreme Court as to what they can declare as the law. But whatever the Supreme Court declares as the law is binding on all courts in the country, which means it becomes effectively law for the future. So our courts can also make law in addition to our parliament. So our courts can add to the existing laws. They can do away with some of the older laws. So this common law constitutionalism is something that we have in our legal system. Now, this is also one of the principles that have come to us through colonization. We were colonized by the British, and principles like this, since it was judges even in the times of the East India Company and later when we came under the crown in 1858, well, these principles were already established here, and we had a lot of English judges who were trained to work in furtherance in accordance with these principles, and they, in the course of their working, made these principles a part of our legal system. Has colonization left an imprint on our law? The answer to that is yes. There are various colonial powers which have ruled over our territories, unfortunately. One example can be the Portuguese, who ruled over large territories, including this city of Mumbai, at one point of time. At that time, we did not have a city. It was a set of 7 islands. But some areas where they had their rule run for a very long period of time, about 400 odd years, is Goa. And plus areas of Daman, island of Diu. In those territories, we had the Portuguese who were the colonial power for a very long period of time, besides some other areas where they were there for a lesser period of time. In those areas, the Portuguese civil code still continues to be, or the principles drawn from the Portuguese civil code still continue to be a part of the legal system. Yes, whatever changes the Portuguese have made after the independence of Goa, after the liberation of Goa, Daman and Diu, those are not to be included, but whatever they brought in, whatever they applied before the liberation of Goa, that continues to be a part of the legal system in many forms in those territories, in those areas, particularly their civil code. That is then the British, who ruled over much larger territories in our country and consistently for a very long period of time, they've also left a strong imprint. As we have already talked, the common law constitutionalism that we see, that is a product of the effect of the legal system that we have. But if you look at laws which we have made even after the British left, I'm not talking about only the laws which the British brought in. I'm not just talking about laws like the Contract Act or the Insurance Act of 1938, or the Partnership Act, which are very similar in principle to what the English law on the issue is, even those laws which we have framed after the British left, they have also a strong British influence. Look at the Hindu Marriage Act, for example. Hindu Marriage Act primarily is a reformatory law. Hindu Marriage Act has lots of elements which are reformatory. And when we adopted that law in the 1950s, it included many principles which the British had included in their marriage law in the 1930s. So 20 years later, we brought in the same principles. So particularly, for example, if we are talking about grounds of divorce, if you look at Shastric Hindu law, there is no provision for divorce. Shastric Hindu law talks of marriage as a sacrament, something that has to go on for 7 births and rebirths. It is not something that can be dissolved by consent of the parties to the marriage. Neither can you enter the marriage, neither is consent important at the time of entering into the marriage. There is no contractual element in a Hindu marriage, if you look at it in Shastric terms. And similarly, you cannot dissolve this marriage also in Shastric terms. But does that mean that there were no divorces before 1955 in Hindu society? The answer to that is no. In addition to Shastric tradition, there was customary tradition also. Under customary tradition, in many communities, because customs are always localized, customs are always, they apply to some sections of society and they don't apply to other sections. So in different sections of society, there were different grounds of divorce. Customary divorce was available in many communities. Or a divorce-like situation was available. A separation, a marked out separation, a recognized separation was available in many other communities. Divorce-like situations were also there. But there was no settled, consistent grounds of divorce. There wasn't a set of consistent grounds of divorce. Now, those were brought in by the Hindu Marriage Act, where this contractual element came to be introduced, where marriage could be brought to an end. It is possible to end this marriage. Then, when the British again modified their law on divorce, when they, in the 50s, they accepted this idea of mutual consent as the basis of divorce. We adopted the same idea by amending our Hindu Marriage Act in the 1970s. So our colonization has left a strong imprint on us. Even our present day laws sometimes, even our post-independence laws are sometimes influenced by our colonial masters. When the colonial masters were ruling us, at that time, of course, so many legal principles. If you look at the law relating to trusts, if you look at law relating to companies, if you look at law relating to partnerships, if you look at law relating to contracts, if you look at law relating to insurance, law relating to banking. So most of these laws, they reflected the same principles which were followed in the legal system in the UK. So in the UK, many of these laws were unwritten. In the UK, many of these laws were derived out of either common law or of equity. But in India, when these laws were brought in, they were brought in codified form. So in India, these laws have been brought in by statutes or the acts which we have. Even law of evidence has a lot of elements that are of common law origin, which have their roots in common law, idea of provision of justice. So this is what I wanted to talk about law and social change. So has colonization had an effect? Has colonization had an effect on our legal system? The answer is yes. It had an effect in the past. It was much stronger. Even today, some elements tend to get reflected in our legal system. So in most common law countries, there are shared principles. If in one common law country, a certain form of legal development takes place, we see that over a period of time, the other common law countries also tend to evolve similar principles and incorporate them in their legal system. Sometimes they pick up an idea directly from elsewhere, sometimes they evolve it within their system. They modify it slightly in the course of this evolution within their system. So, colonization, if we talk about transfer of property, came to be reflected in our transfer of property law in India. So, colonization had a significant impact, high impact on our legal system and continues to that impact continues to subsist in many forms. Yes, courts have been taking a natural law approach, the expansion in the meaning of fundamental rights, incorporation of greater and greater human rights principles. That has happened. Adaptation of that in the context of India has also happened. That is only, that is one side of things. But on the other hand, there are a lot of things that are of colonial origin, and we are continuing with many of those. So we have a combination of both. We have our own reforms also that happen side by side, but at the same time, we have been following a lot of what the colonial masters left us with. So it's a combination of that we follow. If things work to our advantage, we continue with those. Look at the law relating to landlords and tenants regarding property, giving possession so much importance regarding, possession is very strongly protected in our legal system. The roots of that are in the colonial law. In India, if we go by Shastric tradition, that is not something that we see in the modern day legal system. The protection of the possessors is far stronger. The roots of that are in the English legal system, which further adopted it from the Roman legal system. So some elements of Roman law did go to English law. It's not that the two were totally different. Somewhat they were primarily different, but some elements are common. So those Roman law principles regarding possession got modified, got incorporated in common law, and those common law principles later came to be a part of our legal system. Law relating to adverse possession, law relating to prescription, all these have their roots in the colonial law that we had. So this is the first part. The second part of the syllabus, I think we can devote some time to that also. Just a quick look with the 15 odd minutes that we have. So in that we can talk a bit about religion and the law also. Now, when we talk about religion in India, let's first look at and to secure all its citizens. Religion also. Then, more importantly, liberty of thought, expression, belief, faith, and worship. Quality of status and of opportunity and fraternity. All these four elements: justice, liberty, equality, and fraternity. Uses the word secular, and this secular is the term that we use in the religious context in India, by and large. So I'll come to that also. This term secular came to be introduced in our constitution through the 42nd Amendment. So we'll come to that after this, but just to begin with. So if we look at the substantive provisions of our constitution, we have as a part of fundamental rights, right to freedom of religion, which is reflected in Articles 25 and 26 of the Constitution. If you look closely, it talks of this of various forms of this freedom. This freedom of religion is not merely freedom to practice religion, as that is the case in many other countries also. Freedom to practice is something that is provided by many countries. In India, we go much further than that. We have this freedom to preach religion also. We have the freedom to propagate religion also as a fundamental right. So allowing somebody to practice his own religion, his own faith is one part. In addition to that, if people already are a part of that religious belief, they must be educated, they must know further regarding that belief. For preaching is also allowed. And if you want to attract others who belong to different religion, who belong to a different faith, you can bring them into your own religious fold also. This is also a fundamental right, and that is the right to propagate. Sometimes we say that in India, this freedom of religion is restricted, as there are anti-conversion laws. Many times newspapers refer to certain laws as anti-conversion laws. Let's understand that right to freedom of religion, like any other fundamental right, it's not an absolute right. It is a right that should be exercised within certain parameters, within certain limitations, which are laid down in 25 25 clause 2. So when it comes to issues of health or morality, issues of public order, so in such matters, sometimes there might be restrictions on freedom of religion which may be imposed. So freedom of religion is, and the limitations on that are also not exhaustive as given in the Constitution. That is also kept open-ended. But nonetheless, right to freedom of religion is enshrined as a fundamental right. Although, like other fundamental rights, it is a limited right. It is not an absolute right. It is a right that is to be exercised within certain limitations and parameters. Then I also mentioned that we have secularism as a term reflected in the preamble. Well, to begin with, our Constitution did not have this word. The preamble did not have the terms socialist, secular, and integrity. These three terms were introduced with the 42nd Amendment in 1976. And as you all already know, in 1976, we had the emergency that was applying in our country. It is during that time that 42nd Amendment to the Constitution took place. So the debate on 42nd Amendment also was a limited debate. It did not happen to much of an extent. And 42nd Amendment, it was a sort of mini constitution in itself. Many of the changes that were brought in through the 42nd Amendment were undone later in the 44th Amendment. But the point that I'm trying to make here is that the term or the word introduce a word in the preamble. Does it make any change? Does it have any effect on the substantive provisions of the Constitution? The contents of Article 25 continue to be the same. Contents of Article 26 continue to be the same. Change a word in the preamble. Preamble doesn't apply directly. Preamble is not justiciable. Fundamental rights are 25 and 26 are. So does that change anything? The answer to that is there was a difficulty that arose because of the introduction of this term. The idea of secular, as it was understood at the time when this word was introduced in our Constitution in 1970s, this talked of a total separation between the state on the one hand and religion on the other. The roots of secularism are in the distinction to be drawn between the state secularism as it is understood in the West, as it is understood in Europe. It means a total separation between the state on the one hand and any connection with each other. They should not work under the influence or at least the state should not work under the influence of religion. That is the idea behind secularism. Now, this has been interpreted differently in different parts of the world. Now, in the 70s, when we introduced this word into our constitution, France was already using this term. Turkey was already using this term in its constitution. So, if we look at their legal systems, in France, all state institutions and the people who represent the state, people who are a part of those institutions, they should not have, or they should not carry any religious identity in the course of performance of their public functions. Let's suppose I'm a student in a school or in a university that is run by the French state. It is funded, let's suppose, by the French government. When I go to work in that university, or when I go to study in that university, my religious identity should not be something that is visible, something that is, because when I stand there as a let's suppose I teach at such university, if I stand there, I would be seen as a representative of that university. And since the state should not have any religious identity, I should also not reflect any religious identity, right? So let's suppose, being a Hindu, I might want to wear an Om symbol around my neck. When I'll have to go to work in a French secular or a French government-run institution, I would have to hide that. I would not be allowed to display that, because as a representative of the state, as a part of a state institution, I should not reflect any religious identity. So that is the way this idea of secularism was understood in the West. Turkey had something similar. Now things have changed in Turkey in the last 20 odd years, but till 20 years ago, and Turkey has this word secular in their constitution since 1923. There also, in government offices, the people who worked there could not wear anything that reflected or that showed their religious identity, that made their religious identity obvious. So the state cannot reflect any religious identities. People working in state institutions, people representing the state, they are not supposed to reflect any religious identity. In India, on the other hand, that was not the case. The way our Article 25 and 26 were worded, our country is more plural than secular. I'm talking of the word secular in the Western sense here, in the European sense here. So, since we use this term in our preamble, we had to give it a new meaning in the Indian context. So, Indian secularism is seen to be something that is different from Western secularism. In Indian secularism, this clear distinction between the state on the one hand and religion on the other, that is not there. The only important point here is that the state should not be funding, the state should not provide finances to any religious institution. That is the sort of norm that we follow. But otherwise, like I work in a government funded university here, I can wear my religious identity to work. So there is no real bar on it. There is no, since there is no uniform that is imposed. So since we can wear anything that is of our choice, as per, until it is offensive to somebody. Of course, I cannot wear anything that hurts somebody else's freedom of religion or hurts somebody else's religious sentiments. But nonetheless, otherwise, I can wear, since there is no prescribed code for dressing, I can wear an Om symbol, I can wear the red thread around my wrist, I can go to work. That is perfectly in accordance with our constitutional provisions. So Indian secularism is different from Western secularism. Indian secularism is more inclusive, it is more plural. Moving further from this, another important element that is reflected here, we just have 4 or 5 minutes. There are minority rights to to the running of educational institutions that are incorporated into our constitution. They are also part of fundamental rights. These cultural and educational rights, as they are called, they are included in Articles 29 and 30 of our constitution. And as per these articles, both linguistic minorities and religious minorities. So since here we are talking about law and religion, religious minorities is our area of focus. So here the religious minorities are allowed to set up educational institutions of their choice. Although this provision was included in the constitution for the purpose of protection of language, script and culture of these communities, but now this is widely interpreted, and any kind of educational institution can be set up as a minority educational institution in India. If a religious minority is setting up this institution, whether it is a professional college like law college or management college or medical college or engineering college or dental college, although it has nothing to do with the preservation of language, script and culture, this is given a wide interpretation as the words used in the article are institutions of their choice. So any such educational institutions may be set up by religious minorities. They also not just can set these institutions up, they can also administer them. Since there are a couple of minutes left, what can administer mean? I'll just mention a few case laws. If you go through them, you'll understand those, because I have to wind up within a couple of minutes. One would be St. Stephen's College versus University of Delhi. One would be this related to intake of students, whether the intake of who should be chosen as a student in an educational institution, is that a part of right to administer? Can the state interfere in this, or is the minority educational institution autonomous in deciding who should their students be? So on this issue, we have this case of St. Stephen's College versus University of Delhi. Then we have St. Xavier's College versus State of Gujarat. This is regarding employees and their rights. Then we also have a case, although it relates to a linguistic minority, but the principles laid down are applicable to religious minorities also. That is DAV College, Jalandhar versus State of Punjab. This relates to, can the state appoint a member of the management committee of a college if it's a minority educational institution? Then how much fee should be charged from students? Can the state regulate the fee of minority educational institutions? This was an issue that came up in the case of Father Thomas versus State of Maharashtra. So then some more principles are discussed in TMA Pi Foundation versus State of Karnataka, particularly in relation to who should be treated as a minority. How is a minority to be assessed? Should minority be decided on the basis of country as a whole, or should minority be decided on the basis of state by state or area by area? So on this issue, some of the judges, not all of them, have commented in the case of TMA Pi Foundation versus State of Karnataka. So it's already 6 o'clock. So with this, I think I'll have to wind up my talk now. I hope it is fruitful, it was useful for you. And thanks once again to everyone at the Department of Law, the head, and all the professors, associate professors, or my seniors, as well as my colleagues, for allowing this chance, this opportunity to interact with students of all groups, to talk with students of all groups. Over to Alka ma'am, please. All right, I think there is some communication issue. And with this, I think we can bring today's talk to a close, because the next talk is about to start at 6 o'clock. So with this, we bring today's talk to a close. Thank you all very much for being a part of this.